Good afternoon or good morning, still good morning to all. As we begin, we wish to remind that on the brief circulated to the teams, you would have seen the blurb on court etiquette. It contains some important guidelines. We wish to remind everyone, and especially those taking part in our 15th CCJ International Law Moot, that the core values of respect and courtesy must be extended not only to the court, but to your colleagues, the CCJ staff, and all those with whom you interact. Thank you very much. Madam Registrar, please call the matter.
Thank you, Madam President. Hearing of the 15th Annual Caribbean Court of Justice International Law Moot. In the matter of Moot 004 of 2025 between the State of Antigua and Barbuda and the Republic of Guyana. The members of this morning's panel are Madam Justice Rajnath Lee, President and Presiding Judge, Mr. Justice Jamadar, and Madam Justice Ononuwu. May we have the appearances, please?
The Belgrove, and we're instructed by Ms. Soraya Singh.
Thank you, sir.
Much obliged, Your Honor.
May it please the court, I'm John Applewhite Hercules, Senior Counsel for the defendant. I'm joined by my junior counsel, Mr. Fabian Green, and we were instructed by Mr. Master Augustine. Thank you.
Very much, sir. The State of Antigua and Barbuda can begin.
May it please the court. Your Honors, we are here to address the issue of discrimination by restriction, Your Honors. Your Honors, as the first speaker, it is my duty to demonstrate to you that the Republic of Guyana, through their local content policy 2020 and a public production sharing agreement, rather, Your Honors, ExMobile has violated the revised Treaty of Chaguaramas. Your Honors, I will do that in 3 ways. I will firstly highlight the particular articles provided by the revised Treaty of Chaguaramas. I will secondly outline the conduct of Guyana, and finally, I will demonstrate to this court how the conduct has amounted to a violation of the RTC, Your Honors. Following my presentation to this honorable court, Your Honors, my co-counsel will follow up and further demonstrate how the Republic of Guyana has failed to meet the requirements set out in Articles 43 and 47 in relation to restricting the particular rights provided by the RTC, Honors. And with the permission of this court, Your Honors, I would like to commence on my presentation.
Yes, please, go ahead.
Much obliged, Your Honors. Your Honors, The revised Treaty of Chaguaramas clearly provides at Article 7 that member states must not, on any grounds of nationality, discriminate member states within the community, Your Honors. And it is our understanding of that provision, being that the RTC understands the importance of the community, being the CARICOM single market and economy, Your Honors. In Article 7, Your Honor, we see the violation of this particular provision through the local content policy of the Republic of Guyana, which provides for forced consideration. It provides for preference to Guyanians, and more importantly, Your Honors, it provides for a minimization of employment of foreign nationals, Your Honor, which we believe goes against the intent of the revised Treaty of Chaguaramas in Article 7. Your Honors, if I might direct you to the case of Tomlinson Maurice out of this honorable court, and at paragraph 56 of the judgment, the court would have noted, Your Honors, that this is a necessary aspect referring to the free movement of nationals of the rule of law, which has indicated the basic notion underlying the Caribbean community. And in this, it advocates that the legislation or the statute provided by each member of the community must be harmonized with the community law.
Mr. Corbin, please, I wanted to just take you a step back before we get into whether the particular provisions have been breached. Can you establish for the court the position of the state of Antigua and Barbuda as to whether the local content policy, the production sharing agreement, and the community agreement are acts of the state of Guyana which are subject to challenge? Can you first clearly state the position of the state in that regard, please?
Yeah, I'm much obliged if I could seek some clarification.
Right, so the local content policy, is this an act of the state which may be challenged? The production sharing agreement, a contract between the state and a private party, is it an act of the state that can be challenged? The community agreement, which is an arrangement between HexMobile, a private corporation, and the indigenous groups, also non-state actors, are those acts of the state of Guyana that can be challenged? Because without establishing that, we can't really move on to assess whether there are breaches that have been committed. So if you could clarify the state's position on that, please.
Guided, Your Honor, it is our submission, Your Honor, that based on an understanding of what has been set out in the revised Treaty of Chaguaramas, is that each state is allowed the autonomy or the authority over their particular jurisdiction to properly enact the intention of the revised treaty, Your Honors. With that being said, Your Honor, if we are to be guided by this court's judgment in TLC, it has provided that the acts of a state can be, well, sorry, Your Honors, it has provided that the particular operations or the mechanisms of the state that are provided in such instances a local content policy being one of those instances.
Mr. Corbin, let's try and just stay with the question. Question is, there are 3 documents that we are interrogating, yes?
Yes, Your Honor.
Yeah. you must find something done by the state in order to begin to invoke protection under the RTC. So the question is the LCP, the local content policy, can you say that is an act of the state, an act of state? Would you say it is an act of state? And if so, why?
Yes, Your Honor.
Yeah, why?
Because it is our position that a policy by a state represents a position of that state. And the policy is understood to be the mechanism through which a government is able to execute its mandate, Your Honor.
So an executive act, as for example in this policy, is an act of state. All right? Yeah, okay, good.
Guided.
What about the productions sharing agreement? Would you say that is also an act of state? And if so, why?
Your Honor, it is our position that the local content policy has created a legal or an environment through which Hex Mobile is now acting in pursuance to what the government has put forward as their mandate, thus constituting an act that can be attributed to the state of Guyana in this particular instance, Your Honor. And the same will be applicable to the private agreement with Hex Mobile and the indigenous peoples, Your Honor, because these two acts are now derivatives of the local content policy. And it is our submission, if not for the local content policy, there would be no PSA, and there would be no agreement with the indigenous community in Guyana, Your Honor.
Now, Mr. Corbin, is there any applicable rule of international law that can guide the court in understanding how one can attribute the actions of private actors to the state? And has that rule or standard been met here? With respect to the community agreement, that is.
Your Honor, the case of TCL versus Guyana, Your Honor, is instructive in this manner, Your Honor. But before I attempt to provide an answer, Your Honor, I would just like to seek further clarity
Sure.
on the point which the bench wishes me to address.
Sure. So I'm drawn to the first page of the state submissions. The state has suggested that because Guytrin, and I'm quoting here, tacitly approved the agreement, Hex Mobile's agreement with the indigenous groups, that there apparently has been a breach of, I think here what is being alleged is a breach of Article 7. Is tacit agreement of the community agreement by the state enough to attribute the actions of Hex Mobile to this Republic of Guytrin?
Much obliged, Your Honor. There are two ways which we can approach this, Your Honor. Firstly, I would like to point out to this honorable court that while the agreement of with the indigenous community is an essential part of our case, the state of Antigua and Barbuda accepts that this may not be the strongest example of the breach which we are asserting that Guytrin has violated, Your Honor. However, if we are to look at the acts holistically and we are to assess the effect, which is my second point, Your Honor, to be able to determine the liability that Guytrin must accept in this instance, Your Honor, we must assess the effect of such agreements, Your Honor. And the agreement in itself, by providing a preferential treatment, Your Honors, to the tenders brought by the Kalino and the Lucano indigenous groups, Your Honor, is in direct violation of Article 7, because Article 7 provides that there must be no discrimination on the sole basis of nationality, Your Honors. It is our contention that they are not just indigenous peoples residing in Gaitrin, but they are indigenous people residing throughout the community, Your Honor. And as this respectful court in the case of Mayor Leaders Alliance and the Attorney General, Your Honor, 2015, appellate jurisdiction, 15, Your Honors, it stated that the effects or the treatment that has been met out to the indigenous people in historically did not just affect one class of persons, Your Honor. So it cannot be an instance where the government could allow this particular differential and preferential treatment to a particular class of indigenous people.
Mr. Corbin, is Article 7, and we see it projected on the screen, is Article 7 standalone provision, meaning does one establish a breach of this particular provision without linking it to rights that are granted under the treaty?
Guided, Your Honor. And that would lead us to the first direct violation that we see, Your Honor, because it is true that the Article 7 is not a standalone right, Your Honor. We affirm that. And I will demonstrate to you how the limitations of Articles 32, Articles 36, and Articles 46 have amounted to a direct violation of Article 7. And Your Honors, if you would permit me at this point to clarify the framework of our arguments, Your Honor. Articles 32, 36, and 46, respectively, provide for, one, the seems that the nerves are overcoming me, Your Honor. And I will ask permission from this court to read from the RTC, Your Honors.
Yeah,
But-
Mr. Just take your time. Yes, you're among friends, so don't let the nerves get the better.
Thank you.
It
Thank you.
happens
Much
to everyone
obliged.
as well. Yes.
Much obliged, Your Honor. Article 32 provides, and I would like to show the court the specific terminology. It was only yesterday in this honorable court when we heard from Justice Sanders in relation to the nature of this article of the revised Treaty of Chaguaramas, and he noted that there are particular provisions placed, and it is a deliberate attempt from the states to reflect a particular intent. And in this case, the framers of the RTC has chosen to phrase this particular right as the prohibition of new restrictions on the right to establishment. It is not entitled the right to establishment, Your Honor. It is entitled the prohibition, which means two things, Your Honor. That this is intended to be a right provided by the revised Treaty of Chaguaramas that must be seriously guarded.
All right, so Mr. Corbin, is there anything that prevents non-nationals of Gaitrin from establishing businesses in Gaitrin?
No, Your Honors. However, in the case of Tomlinson, in the case of TCL, as I would have noted before, this court has noted that these rights are correlative, Your Honors. And with the indulgence of this court, I would like to posit two ways that we can approach this, Your Honors. Firstly, correlative being in the sense that these rights, as Your Honors noted earlier, cannot stand alone, Your Honors. But I would go further to state that the provision or the right to establishment, Your Honor, is premised on the ability of a member of state to move. thereby it correlates and it is symbiotic with Articles 36 and
But
Articles
is there,
46.
is there anything in the LCP or the PSA that prevents non-nationals from moving, establishing businesses, moving capital? Is there anything in there that prevents that? Why is this on the factual matrix? Why is this a new restriction that is undermining the right to establish business, the right to move, the right to provide services? So maybe step one, is there anything on the face of it that prevents a non-national from establishing a business,
Yes.
entering the country? Yeah.
Yes, Your Honor.
What-
While
what?
it is our position that nationals are still allowed to move freely and establish themselves, Your Honor, by labeling or by terming minimization of foreign employment, priority employment, preferential treatment, first consideration, Your Honors, is the language of discrimination, Your Honor. And while it does not inhibit the ability of a national to move from Guyana to Antigua and Barbuda, or vice versa, Your Honor, it limits the full access as outlined in Tomlinson and TCL that each member of state must have, Your Honor. So it is not simply the ability to set up, but is the ability to enjoy the full access and benefit in the same manner that the Guyana citizens should be allowed to do it. And on that point, Your Honors, we are submitted that Guyana has violated, whether it be an indirect violation, Your Honors. Because if we are to take the ruling of Shanique Myrie, Your Honors, which came out of this court as well, it was noted between paragraphs 84 to 88 that when we are assessing a breach, in order to determine the severity of the breach, we must not be limited to the evidence presented, but we must assess the effect of the particular breach being claimed, Your Honors. And it is our contention that the effect of minimizing foreign employment, the effect of first consideration, Your Honor, the effect of providing adequate opportunity and giving preference to Guyanian suppliers and service providers, Your Honor, will now prevent nationals from all over the community from being able to pursue their rights, Your Honor. And while
Mr. Corbyn, I don't want to stop you in full flight, but I need to let you know that you have 13 more seconds. But we have asked you several questions, so we'll give you 3 extra minutes.
much
So
obliged.
use them wisely.
Much obliged,
Thank
Your Honors. And to really tie this matter in, Your Honors, the first thing that we must keep in our minds is that the LCP is attributable to the state, which by extension means that the PSA and the agreement with the indigenous peoples are attributable to the state of Guyana, because as established, the policy represents the engine room of a government setting forth how they intend to execute their mandate. And it is within the best interest of HexMobile to ensure that they are in line with that mandate, Your Honor. Secondly, Article 7, while we accept that it has been breached, Your Honors, it is not a standalone right. And it is by the limitations of Articles 32, 36, and 46, when we look at it in the regime of what was intended in the RTC, which is regional integration, economic cooperation, that these rights must not just be enjoyed, but they must be enjoyed in the same way that any member of state in any particular CARICOM state must be allowed to enjoy, Your Honor.
Mr. Corbyn, before your time runs out, I just want you to clarify something. So you did speak to the aspects of the initiatives of that we're looking at that concern priority being given with respect to employment and priority being given with respect to procurement. what about the provisions concerning training or other capacity development of Guytrinians? How would those provisions constitute any kind of restriction on the exercise of the rights in question by community nationals? The training or other capacity development requirements?
Your Honor, the core part of the LCP that we are concerned with, Your Honor, is the preferential, the minimizing. So we have no particular issue with Guytrin providing for training of its nationals.
So wait, hold on. You're not contending that the training part of the factual matrix infringes the rights in 32, 36, or 46?
Could you please rephrase, Your Honor?
You are you, is it that you are not contending that the training requirements in the LCP, that they do not infringe 32, 36, and 46?
Yes,
You're
Your
not
Honor.
contending that they, all right.
That is not.
You are
that is not the
concerned
argument.
with the right to establish, the right to move and provide services.
Yes, Your
Yeah.
Honor.
And more particularly, the provisions relating to first preference being given or priority being given to procurement and priority being given with respect to employment.
That is the exact point that I am attempting to make, Your Honor.
Thank you.
And if
Mr.
at this stage I could be of no further assistance to this honorable court, that is my submission, Your Honor.
Thank you very much, Mr. Corbin.
Much
Appreciate it.
obliged, Your
Yes. And the nerves that leave you off.
Honor. Thank you, Your Honor.
Be encouraged. And the junior counsel for Antigua and Barbuda. Miss Singh, is it?
Good morning, Your Honors. It's Miss Belgrove.
Miss Belgrove. Thank you very much, Miss Belgrove.
Good morning, Your Honors. As previously introduced by my co-counsel, I am Marquisa Belgrove, representing the state of Antigua and Barbuda, and I shall address the second limb of our arguments this morning. Your Honors, the claimant submits before this honorable court that Guytrin cannot rely on Articles 43 and 47 of the revised Treaty of Chaguaramas to justify their breaches of Articles 7, 32, 36, and 46 of the revised Treaty of Chaguaramas. Your Honors, we found this submission on the fact that Articles 43 and 47, to place reliance upon them, require adherence to the regulations and procedures laid down in Articles 43 and 47, Your Honors. Firstly, under 43, Guytrin needed to have, according to sub-article 2, A to D, Your Honors, when imposing their restrictions, not discriminate against other member states or against member states in favor of third states. They must seek to minimize the damage, Your Honors, to the commercial, economic, and financial interests of other member states. Their measures shall not exceed what is necessary to deal with the circumstances they face, which we acknowledge Guytrin has faced difficult economic circumstances. And one of the most important points, Your Honors, is that their restrictions shall be temporary in a period no longer than 18 months, Your Honors, and progressively phased out as the situation demands. Additionally, Your Honors, under Article 47, Guytrin needed to have notified quoted and COFAP prior to the implementation of these restrictions, Your Honors. And if their situation was so dire that they could not notify quoted and COFAP before implementing the restrictions, Your Honors, they needed to give this notification immediately after imposing such restrictions. Your Honors,
Just before you go on, under 43, there's also a notification requirement, isn't there?
yes, there is a
43.3, right?
yes, there is a notification requirement as well within 3 days,
3
Your Honors.
days, yeah.
And Gaitrin has not, Your Honors, as we can acknowledge, fulfilled this requirement. The LCP and PSA came online in 2020.
Is it, I don't think it is disputed that they have not met these procedural requirements, certainly not notification. So is that fatal? Does that mean that having not met those procedural requirements, they cannot rely on the restrictions in 43 and 47? Is that what you're going to argue?
Yes, Your Honors. That is the core of our argument today, Your Honors. That, and it was explored in the case of Trinidad Cement and Guyana, 2009 CCJ 5 in the original jurisdiction, at paragraph 43, Your Honors, if I may have the court's permission to read a
Yes,
particular
go ahead,
line.
please.
Yes, Your Honors. In a similar, though not exact situation, Guyana did not consult, Your Honors, and the court noted that Guyana could not explain the continued unwillingness or refusal to honor its treaty obligations by seeking prior approval of COTED. This flagrant breach has persisted throughout the pleadings down to the commencement of the hearings, Your Honors. Your Honors, this honorable court.
Ms. Belgrove, let's just look at that. I understand that you've said the two cases are not on all fours, but is that really helpful to the court comparing a situation where there was no prior consultation before a member state unilaterally decided to not apply the correct CET to a product on the one hand, which is what was at play in that case, and the failure to give a notification to community organs in circumstances where a member state is facing serious external difficulties, which I think the state of Antigua and Barbuda has accepted that the Republic of Guyana was facing. So do you really think that case is helpful to have us answer the question that Justice Jamadar just posed?
Yes, Your Honors. And it is helpful for this particular reason. It is helpful, Your Honors, because the principles remain, even though they are differential, it's a different basis, Your Honors. The principle remains that where the RTC creates an obligation on a state, no matter the situation, we as member states who have signed on to the RTC must adhere to this obligation. And in this particular situation, Your Honors, in our present case, there is an obligation on Guyana to notify COTED and COFAP. And Your Honors, further to this point, we need to look at the effect, Your Honors, of the lack of consultation in the case of TCL before, and we need to look at the effect of the lack of consultation in our present case, which is to do economic harm, Your Honors, which is to reduce the rights.
Ms. Belgrave,
enjoyed.
I just want to raise something with you about this. The factual matrix suggests you brought your action in 2024. The policies were put in place in 2020. But in 2022, all of this was brought to the attention of CARICOM, the heads of government, and they set up a working group to make recommendations to deal with this exact situation, not a similar situation, this particular situation. Yes?
Yes.
Would you therefore say that COTED, COFAB, CARICOM have in fact had notification and have notice of what is happening and have gone beyond notification and actually put in place a working group to try and come up with proposals to deal with this situation?
To answer your question, Your Honor, there are 2 points I must raise. Firstly, our claim before this court deals with the fact that there was no prior notification. So on that grounds, we submit that the breach has already occurred. Secondly, Your Honors, we acknowledge the existence of the working group, and we acknowledge the current position that CARICOM and Quoted and COFAP are aware of the situation. However, Your Honors, we are here before this honorable court because the working group was implemented in 2022, and we have not heard word from the working group, Your Honors. We are before this court as a last resort, Your Honors, because we need this honorable court to give relief to Antigua and Barbuda, Your Honors, to give relief to other CARICOM nations and compel an answer from Quoted and COFAP and compel consultation and compel adherence with the revised Treaty of Chaguaramas, Your Honors, from Gaitrin.
Ms. Belgrove, have you joined the community to this claim?
Your Honors, we acknowledge that the community appears amicus curiae in this claim. We have not joined them, Your Honors, but the principle stands that any decision from this court in this matter does not only affect Antigua and Barbuda, but it affects all member states presently, Your Honors.
So you are amending your originating application to?
No, Your Honors.
No,
not
and
it.
are you seeking from this court declarations against the community?
No, Your Honors. Our relief is today, Your Honors. We seek only a declaration against the actions of Gaitrin, and we seek that you compel Gaitrin, Your Honors, to work with Quoted and COFAP and member states of the community to revise and revisit their LCP and bring it in line with the RTC, Your Honors.
Ms. Belgrave, that's my little challenge. You want us to compel them to go to Quoted and COFAB, but they're already there. It seems what you want to do is to compel Quoted and COFAB and CARICOM to act on what is already before them.
What we seek, Your Honors, to be perfectly clear, is immediate relief, Your Honors. So the order that we would like you to compel Gaitrin and Quoted and COFAP is not just to have the consultation, but to revisit the LCP immediately within the context of the consultation, Your Honors.
Thank you.
Yes, we follow you. You may proceed.
Yes, Your Honors. So, as we previously discussed, Your Honors, and my co-counsel raised the point, under Articles 43, Sub-Article 2A, Gaitrin was required to have their measures not discriminate, Your Honors, and it is our submission that Gaitrin's measures are discriminatory, Your Honors, on the sole basis of nationality, Your Honors, by giving...
Ms. Belgrove, let's revisit subparagraph 2A of Article 43. Is the standard of discrimination, or I should say non-discrimination here, really the same as that under Article 7? When we look at the language of subparagraph 2A, which is to ensure that the restrictions do not discriminate among member states or against member states in favor of third states. Do these restrictions not conform with that requirement? Do these restrictions discriminate amongst member states, or do they discriminate against member states in favor of third states?
Yes, Your Honors. It is our contention, Your Honors, that the discrimination, that the restrictions, Your Honors, discriminate against member states, Your Honors.
No, it says among member states.
Yes. We rely on the second limb, Your Honors, against member states in
Favor of third states?
yes, Your Honors. And while we are saying that our contention is that with the agreement with HexMobile, and we are not saying that Gaitrin cannot agree with have an agreement with another state, Your Honors. Our contention is that
Wait, hold on. Which is the third state?
yes, Your
This
Honors.
scenario, which is the third state? If you're on the second part of A, which is the third state that is being favorably treated?
Your Honors, indirectly, the United States, through their United States registered company, HexMobile, would be receiving some favor from the agreement with Gaitrin, while other members of CARICOM are blocked out or limited within Gaitrin's petroleum
With
sectors,
respect to
Your Honor.
what rights of community nationals? So remember, we're dealing with restrictions on the exercise of certain rights
Yes, Your Honors.
by CARICOM nationals.
And the
How
right-
is HexMobile, I'm following your argument correctly, Ms. Belgrove, how is HexMobile receiving more favorable treatment than other community nationals with respect to the exercise of the rights in question under Chapter 3?
Well, Your Honors, for a very straightforward example, ExMobil is able to come and establish themselves within Guytrin's petroleum sector without any caveats or restrictions. However, our member states, Your Honors, the private sector of Antigua and Barbuda, and are being treated to second preference, Your Honors, are being limited, are having their opportunities minimized, Your Honors.
But these, I don't want to belabor the point because I know you have time constraints, but just bear in mind that we're talking about measures that are imposed on ExMobil with respect to their procurement and hiring practices, no?
Your Honors. we
And
can-
training requirements.
Yes, we contend that the fact that Guytrin has even allowed ExMobil in, whereas we CARICOM states would still need to tender, would still need to make an application that would be given second preference, Your Honors, is the issue in this matter, Your Honors. And that is where we find the discrimination, Your Honors.
Yeah, we understand your submissions on that point.
Thank you,
I
Your
believe you have just over a minute if you wish to say anything that is very important or you wish to wrap up.
Yes, Your Honors. Your Honors, particularly, we would like to address the point of the article under Article 47, Your Honors, the requirement of notification and working with quoted and COFAP, Your Honors, and the effect, Your Honors, that I was going to refer the court to earlier. We would like to address the point that quoted and COFAP are there, Your Honors, as community organs to ensure the appropriateness of the measures implemented by Guytrin and to examine the time period that these measures were supposed to be implemented for, Your Honors. And because of Guytrin's lack of compliance with Article 47, Your Honors, we are in a position where the appropriateness of the measures, Your Honors, the proportionality, and whether they and analyzing whether they meet the legitimate aims or not, and how much harm they are doing to to Antigua and Barbuda, cannot be examined, Your Honors. And therefore, Your Honors, we are of the position that this procedural breach, despite any justification that Guytrin may make about their economic situation, renders those justifications void, Your Honors, because of the fact that it is a fundamental flaw, Your Honors, in this present situation, given the rights that are at stake under the RTC, Your Honors, given the very spirit of the CSME that is at stake, Your Honors, to not have consulted the quoted and COFAP, to not have limited the restrictions to an 18-month period, or to not progressively lessen the restrictions, Your Honors. And if I may be of no further assistance to this court, these are the extent of my submissions, Your Honors.
Thank you so much. Ms. Belgrove, thank you. Senior Counsel for the Republic of Guytrin.
May it please this honorable court. I'm John Applewhite Hercules, the senior counsel for the defendant, the state of Guytrin. Your Honor, the matter that has been brought to you before this honorable court by the applicant has been misconstrued, and when closely analyzed, can be found to have no merit, that this court should grant special leave in the first instance to the applicant. This court should deny such special leave. And in the other instance, not make any declarations as requested by the applicant.
Mr. Hercules, may I shorten your name to Hercules?
Yes, ma'am.
Yes, thank you. Mr. Hercules, the other side are seeking special leave. They are seeking special leave in this case?
Your Honor, procedurally, the applicant should be seeking special leave.
Under what provision
Your Honor,
of the RTC would a member state seek special leave, Mr.?
Your Honor, I take the point that you've made, but whatever the relief that the applicant has requested, we say that such relief should not be granted.
I follow you.
Your Honors, our submission will take three bases. We will examine the issues that arise in this case by looking at the fact that the actions of Gaitrin can be classified as an action as governmental authority in nature, which is given a special carve-out under Article 30 of the RTC. The second basis will be to look at the administrative conduct of the state of Gaitrin and to assess whether the elements of the conduct of Gaitrin, when juxtaposed to the obligation under the RTC, particularly Articles 7, 32, 36, and 46, whether they amount to any restriction or to any breach. It is our position that the actions.
Sorry, I thought you said
And-
three bases. Did I miss?
Yes, and the third basis, Your Honor, the third basis will be to examine the private agreement between Hex Mobile and the indigenous communities, and to see whether that agreement breach any rights, community rights, such as the rights in Article 32, 36, and 46, or if they can be grounded with Article 7. Your Honors, we submit that the administrative conduct by the state of Gaitrin and the actions of the state of Gaitrin, as gleaned from the facts before this court, does not breach Article 7, 32, 36, or 46. I will examine, as I indicated, those first three bases. My junior counsel, Your Honor, will examine from a perspective that if this court, in its generosity, finds that a restriction, a breach exists, then the actions of Gaitrin can still be justifiable under the provisions of 43 and 47, bearing in mind, Your Honors, that we are not required to have strict compliance with the letter and text of the provisions, but we are to have, Your Honor, a demonstration, a reasonable argument to show that our actions are further justifiable under the provisions of 43 and 47. Your Honor, with your leave, may I begin my substantive submission?
Yes, please. You're going to start with Article 30.
Yes, Your Honor.
Okay, go ahead, please.
Your Honor, Article 30 is a special carve-out within the RTC that gives member states a particular right to engage in activities that are classified or categorized as activities and actions
Yeah, Mr.
of
Hercules.
governmental
All right,
authority.
yes, yeah. Let's cut to the chase with Article 3.
Yes, sir.
Does
Yes,
it
Your Honor.
include activities conducted on a commercial basis? Does the carve-out in Article 30 include activities involving a commercial basis?
It does not speak to a commercial activity. And so we want to make the distinction that the actions that have been done by Guytrin are not purely an action that is of a commercial nature, but more so an action of governmental authority. And why do we say so? When we look at the historic background of Guytrin, we see from the facts that Guytrin has been subject to decades of serious economic crisis, being a member of the highly indebted poor countries, having rising rates of unemployment. This sets the basis, Your Honor, upon which Guytrin can stand firmly when it implements its signing of a PSA and the establishment of its LCP so as to foster its own survival, economic, sustainable development to move it from that state.
Mr. Hercules, I want you to help me with something. First, what are the activities in question that you're pointing to? Just so we're clear on what you're considering to be activities for the purpose of Article 30.
The signing of the PSA by the state of Guytrin is an activity under Article 30. The establishment of the local content policy is another activity under Article 30.
Okay, so I'm understanding the argument Guytrin is trying to construct. Now, what I'd like to know is there any jurisprudence of the court that provides clarity on what the purpose of Article 30 is?
Yes, Your Honor. The court can be drawn to the case of Ellis Richards versus the state of Trinidad and Tobago.
Right, we're familiar with the facts. What I would like to know is what has the court already clarified to be the purpose of Article 30?
The purpose of Article 30, Your Honor, has to do when there is a necessity for the state to act, so as to ensure there's, for example, balance of payment. If there's a difficulty with balance of payment in the state, which characterize a serious economic crisis, then a state is afforded approval under Article 30 to take actions of governmental authority in nature so as to bring its economy or to balance its payment.
But Mr. Hercules, isn't the point of Article 30 to completely reserve to the state, to completely exclude from the scope of Chapter 3 certain activities? In other words, these are activities that the state has no obligation to allow other community nationals to engage in.
Yes, Your
The
Honor.
challenge I'm having with the argument you're making is, if we take it to its logical conclusion, government regulation is what you're saying is the activity, or any kind of act of the executive becomes the activity, which then will always be excluded from the scrutiny of the court scrutiny of the action of a member state.
Your Honors, Chapter 3 of the RTC deals with certain basic rights, community rights. The right of establishment, the right of entry, the movement of goods and capital. When an action by the state is done that does not affect any of those rights from a commercial point of view. So for example, in TCL case, the Guyana government failed to impose a tariff on cement from other country. That, Your Honor, that action was seen as a breach because it was affecting another community enterprise, TCL in Trinidad and in Guyana, when they fail to so do, because it makes them in a less favorable position. But when a state such as Guytrin undertake a signing of a PSA so as to foster the development of its natural resource, so as to secure its economic security and to provide the basis upon which the socio-economic position of the country can be improved, then that is a public policy position that is given coverage under governmental authority in nature.
Okay, Mr. Hercules, I know you have some other points to move on to, so I just have one final question on this Article 30 point. Would the signing of a PSA be an activity in which other community nationals would be seeking to engage? Again, we're going back to the purpose of Article 30 here.
Yeah, Your Honor, not only is it Article 30, other community nationals can sign PSA within their jurisdiction, Your Honor. There is nothing that says that they're not entitled to exercise that sovereignty of entering into production sharing agreements with all companies.
But Mr. Hercules, whereas in the case of the LCP, you know, the idea that this is policy and this is about maybe a governmental authority act because it's declaring policy. This is now an agreement between the state and an operator in industry, which is commercial by definition.
Yes,
Why is the state entering into an agreement with Hex Mobile? What's the policy in that?
the policy is to ensure that the
No, the policy is because Hex Mobile wants to come into Guyana and get into the energy sector to make profit, and the state will make profit off of it. Is that not commercial?
Sir, by the same token, we can say that the state has a responsibility to ensure that the economic stability and survival is secured. And given the fact that Guyana has experienced decades of a serious economic crisis,
That may put you in 43 or 47. But remember, we're on 30, but we spent a lot of time on 30. I think we understand what you want to say, and you have limited time. So
yes, Your Honor.
Yeah,
maybe
so
move
just,
on.
yeah, just as you move on, just wrap up what you say that we should do, having regard to your submissions under 30. What is the impact?
Well, Your Honor, the impact is that Article 30 gives the state of Guyana that approval to sign its PSA and establish its LCP, and therefore it cannot be construed as a breach of any community right because Article 30 is a special carve-out of Chapter 30, and therefore Chapter 3, sorry, and therefore cannot be subject to those requirements that are enshrined in Chapter 3.
Okay, so Mr. Hercules, I know your time is limited, so because you wanted to address the administrative conduct of the state and the community agreement, what I just wanted to know is where the local content policy and the production sharing agreement are concerned, does the Republic of Guyana consider these to be acts of the state which can be subject to challenge? Bearing in mind you heard the submissions of the state of Antigua and Barbuda on the point. Do you agree that these are acts of the state of Guyana which can be challenged? And then I'll move on to the same question with the community agreement.
Your Honors, because we rely on Article 30 as the basis upon which the state of Guyana has signed its PSA and established its LCP, my answer to you is that whilst those are acts of the state, it cannot be challenged on the basis of a breach of Article 30.
You're
36.
compelled to accept their acts of state because that's the whole point of Article 30.
Yes, sir.
So you can't deny that they're acts
sir.
of state.
Yes.
All right. So
And the community agreement, Mr. Hercules?
as it relates to the community agreement with Hex Mobile and the indigenous community, we submit, Your Honors, that that's a private agreement that is not justiciable under the RTC. Because, Your Honors, the fact is that when we look around in other CARICOM territories, every day there are hundreds of private agreements between companies and specific demographics. For example, projects to benefit women, project to benefit the elderly, project to benefit children. These are contracts and projects and engagements that affect a particular demographic. So if we were to accept that the applicant's position that this action by HexMobile, this private action by HexMobile to engage the indigenous community amounts to a breach of the relevant articles of the RTC, then that leads to an absurdity because, Your Honors, all the 100 other cases throughout the CARICOM where companies are engaged with specific demographic and not nationality per se. So the question, Your Honor, has to be looked at as to whether the applicant has met the burden. The applicant is required to meet a higher burden. He who alleges must prove. They allege that Guytrin has violated these articles. But where is the proof? Let me bring the proof that came from the applicant's mouth, Your Honor. When the Honorable Bench asked the applicant, for example, the senior counsel, Your Honor, whether the agreement is this agreement, if there's anything that prevent non-nationals of Guytrin from the right of establishment under 32, the answer by the senior counsel was no, Your Honor. And we thank him for that response because, Your Honor, we submit that what the senior counsel and the junior counsel stressed or pleaded before this court was evidence that deals with employment. And therefore, there's a distinction because employment services are wage-based services, whilst Article 32 and its associated Article 36 are relating to non-wage-based services.
Okay,
And
so Mr. Hercules, I have a
Yes.
very specific question because again, I want to give you the opportunity to answer this. Now, let's just let's operate on the possibility that the court may not accept the submission on Article 30. So we find that these are not activities that are excluded from the scope of Chapter 3. And you have indicated that the local content policy and the production sharing agreement are acts of the state. Let's turn to Article 32 specifically. We see on the facts that the local content policy provides that in making decisions concerning procurement to execute petroleum activities, operators and their contractors shall give first consideration and provide adequate opportunity to Guytrinian suppliers where capable and competitive. I have a direct question. Does that in any way impair the exercise of either the right of establishment under Article 32 or the right to provide services under Article 36?
No, Your Honor, it does not.
Okay, can you explain why?
Yes, Your Honor. Your Honor, let's look at the evidence. The evidence is first consideration, not favorable consideration. The evidence is adequate opportunity, not exclusive opportunity. And so when we examine the evidence and attribute the weight that the evidence must be given, we can say we submit that Guytrin contemplated its obligation under the RTC when it established its local content policy. And the language used in the evidence is not discriminatory, but rather first consideration can be contemplated in a case where 100 nationals from other CARICOM states make an application and 5 nationals from Guytrin make an application, but perhaps the 5 nationals do not have the capacity, the technical expertise, but they will be given first consideration and not favorable consideration. But on the basis of merit, technical capacity, and expertise, the other CARICOM nationals are given an equal opportunity to benefit. through the
Mr.
process.
Hercules, yeah, we follow your submission. You've run out of time. We have asked you several questions. We'll give you 2 minutes to wrap up, please.
Yes,
Or
Your
tell
Honor.
us. Yes.
So we submit, Your Honors, that not only does the PSC and the LCP not breach any of the articles, but also the standard has not been met. First, that a community right has been breached, and that this community right was this discrimination of this community right was on the basis of nationality only. The applicant has not pleaded that. The applicant has not directed the court to that fact. And we say because the facts does not exist before this court. Your Honor, my third submission is that when we examine the private agreement between HexMobile and the indigenous communities, as you asked in your question, we say that this agreement really, Your Honor, is not justiciable. The actions are not justiciable under the RTC, but rather it's HexMobile contemplating and committing to this corporate social responsibility as multinational companies do. Your Honor, we also say that this commitment is supported by a evolving customary international law that gives give credence to the fact that indigenous groups must be respected and be given a part to play in the decision making when resources are being extracted in the vicinity.
Mr. Hercules, you're going to have to leave it
May
there.
it please this court? Thank you very much.
Thank you very much. Junior counsel.
It pleases the court, I am Fabian Green, junior counsel for the defendant. Your Honors, my senior counsel would have contended, or my senior counsel contended that there was no breach of Article 7, 32, 36, and 46 of the revised Treaty of Chaguaramas. Your Honors, I respectfully submit that the issues before this court in today's proceedings is an issue of justification. In both Article 43 and 47 of the revised Treaty of Chaguaramas, they both contain provisions relating to justification and provisions related to compliance and procedure. The facts as given only confer upon the defendant a duty to only justify its actions in the event of a breach. Therefore, we are making submission to this honorable court that submissions related to procedures is not the substantive matter before this honorable court in today's proceedings. Your Honor, with your permission, may I proceed with my substantive submissions?
Yes, please.
Your Honor, defendant is contending that in the event of a breach, the actions of Guyana can be justified or is justifiable under Article 43 and 47 of the revised Treaty of Chaguaramas. Your Honors, if you look at Article 43.1, this specific provision would allow member states to maintain or adopt restrictive measures to remedy a financial burden that member state would face. At paragraph 2 of the same article, it conveys that the restrictions maintained or adopted by member states could be quantitative. And the article or that specific portion go further by outlining the conditions on which the restrictions applied must operate on. So if you look at Article 43, paragraph 2A, it states that the restrictions maintained or adopted shall not discriminate. I will not put focus or emphasis on this portion because my senior counsel would have made submission contending that there is no discrimination. As it relates to Part B and Part C, the RTC, it is conveyed that the restrictions maintained or adopted shall at all times seek to minimize damage, meaning it should be proportionate, and it shall not exceed those necessary to deal with the circumstances. We are submitting that the local content policy and the other related agreement were proportionate and it was necessary. Part D of Article 43.
Before you move on to Part D, can you elaborate on, because the burden really is on Guyana as the party invoking these exceptions to ensure that these conditions are satisfied. Why do you consider that these restrictions are proportionate and necessary?
All right. We are contending that the restrictions were necessary because if you look at the facts of express terms like the state of Guyana was battling a serious economic crisis marked by low foreign currency reserves, fluctuating commodity prices, and a rising level of unemployment. It is necessary to enact the local content policy and the other related agreements because the local content policy and these other related agreements sort of remedy the circumstances faced by Guyana. We're also saying that it is proportionate because the local content policy and other related agreement did not create a absolute ban on other CARICOM on other CARICOM member states. Instead, it just gave first consideration. And my senior counsel would have emphasized the true essence of first consideration in his submissions earlier. If we look at the contention here relating to Article 43 would come where the restrictions maintained by member states shall be temporary, but in any event, no longer than 18 months. The claimant alleges that we are in breach of this specific article because the 18 months would have elapsed. Your Honors, we are contending that there is no breach. We're making this submission on the basis that Article 43, as it is, attracts a purposive interpretation and should not be interpreted just on the clear text of the meaning, the clear meaning of the text. This court had shed light on this principle, which is contained in Article 31(1) of the VLCT, the Vienna Convention of Law of Treaties, in the case of Hard Cement versus Barbados, which the claimants relied on. And the essence of Article 31 of the VLCT speaks to that treaties shall be interpreted in good faith in accordance with the meaning to be given to them of the treaty in their context and in light of its object and purpose.
Hold on. You're saying that 18 months, it says here, no longer than, shall be temporary in any way, no longer than a period of 18 months.
Your Honors, we are
18 months doesn't mean 18 months.
Can you please?
18 months does not mean 18 months. The section says temporary, but no longer than 18 months. What's the purposive interpretation you give to that?
So the purpose of interpretation to that is that we're saying that each member states would have had their ideal or have different economic realities. And so we're contending to this honorable court that when the drafters of the RTC was working on this specific article, they did not examine the different economic realities of other member states. Your Honors, we are men and women of the law, we're not economists, and so we have to view that the drafters of the RTC would have not been in a position to put
So
a
are we
put a
to
period.
read down the 18 months? Are you saying that this court, therefore, should read down the 18 months, read it out of the subsection? It says 18 months, right?
Yes, Your Honor.
You are outside of 18 months.
Your Honor, I will
What do we do
submit,
with the 18 months?
Your Honor, as it relates to the 18 months, in Article 43 at paragraph 6, it states that the forums relating to these rights and articles should be confined to COFAP and quoted. And so we are saying that as it relates to the time of the 18 months, if it should be reduced or if it should be increase, we are saying that it's not the court's jurisdiction to deal with that. We are saying that the court should probably direct this issue to COFAP quoted as the forums relating to.
And are
these
you saying it's
portions.
already there because of what happened in 2022 with the heads of government?
Can you repeat it now?
Are you saying that it is already there because of what happened in 2022 with the heads of government and the establishment of the working group on local content?
Yes, Your Honor.
All right.
So that is the extent of my submissions relating to Article 43. I will move on to 47. Your Honors, Article 47 of the RTC would have allow a member state to well, the words of it is saying that where the exercise of rights granted under this chapter creates serious difficulties in any sector of the economy, a member state or occasion economic hardship in a region of the community, it is saying that a member state adversely affected thereby may, subject to the provision of this article, apply such restrictions on the exercise of the rights as it is considered appropriate in order to resolve the difficulties or to alleviate the hardships. Your Honors, we are contended that if there is no local content policy, and if there wasn't a local content policy, and if there wasn't the other related agreements, it would create a serious difficulties in the gas and oil sector in the state of Guyana.
Could you explain that in some more detail, please?
And just to follow on from the chair's question, Mr. Green, paragraph 1, please incorporate this in your explanation. Paragraph 1 would require, it would seem, the state of Guyana to demonstrate that the exercise of these rights has actually created these difficulties.
Yes, Your Honor. So, as it relates to the serious difficulties that I was referring to in my earlier submission, we're talking about exploitation of resources. We know gas and oil is something of wealth, and everyone is chasing after it. And so we are saying that these restrictive measures are necessary because if we don't put policies in place to secure our wealth and to secure resources, we can be in a position where our people or our resources can be exploited. And because our resources are at the hem of being exploited, Guyanians will not be in a position where they can benefit from the resources. And so we are saying the local content policies and other related agreements are put in place for Guyanians to benefit from the resources that are benefit from the country's resources.
So essentially, your argument is a preemptive one, because you are saying it was appropriate to put these measures in place in anticipation that if community nationals were fully allowed to exercise their rights under Chapter 3, there would be hardship.
Your Honor, can you please repeat?
Sure.
Or can you,
So
rephrase?
no problem, Mr. Green. Now, I was pointing you to paragraph 1 of Article 47. It provides that where the exercise of rights granted under this chapter creates serious difficulties. So it suggests that there has to be a demonstration by any state invoking this exception that other community nationals actually exercising their rights has in fact created these. It seems like there's a burden on the Republic of Guyana to show that the exercise of these rights by other community nationals has created these serious difficulties. But I understand the state submission to be, in order to avoid Guyanians not benefiting, it was important to put these measures in place. So even if no hardship had in fact been created, it's almost as if you were anticipating that there would be hardship, and so the local content policy was necessary. So I'm asking you to just clarify if you think that, well, is there anything more you can say to ensure that the state satisfies its burden to demonstrate this linkage? Thank
Your
you.
Honor, at this time, I don't have a response to your question, but we can provide one for you upon the reply.
All right, so just as you maybe your end, I think what you've been asked is, in paragraph 1, it says creates serious. Is it that you're inviting us to read? It doesn't say created. Are you asking us to interpret creates as meaning purposefully something that may have created, has already existed or exists, and something that reasonably can be predicted to exist? Are you asking us to interpret the language of the word in a certain way? That's the question, is trying to interrogate that with you. How do you respond to that?
Your Honor,
Have you looked at section 1? Do you want to look at the first line in section 1? Yeah. So what do you say about that?
And Mr. Green, I just want to encourage you to say what you have to now, because you do not have a right of reply.
Yeah.
So thank you. Take your time and
Your Honor, would you be able to clarify the question one more time?
What you were asked is whether or not in 47(1), which says where the exercise of rights granted, creates serious difficulties, so that it is the exercise of rights that creates the difficulties. You have said that there are difficulties because of the paragraph 1 of the factual matrix, debt payments and so on. So what you've been asked is, it says where the exercise of rights of establishment, movement, provision of that creates serious difficulties. So are you saying that the word creates, as used there, is not limited to already in existence, but creates there means that can reasonably create? Because you put these things in place in 2020, but you only drill for oil in 2021. And while you ponder on that, if you don't, is it that you have to justify under both 43 or 47? Or is it that if you can't justify under 47, the justification of 43 is sufficient?
That is our position. If we cannot justify under 47, we justify under 43.
Yeah, all right.
As it relates to the question that you asked, just before we're saying that a limitation to the rights of CARICOM for the protection of the, in essence, what we're submitting is that the issues are as per paragraph 1, which is stated that the serious difficulties that are created by the exercise of rights, we are contending that they can reasonably occur in the future as well.
thank you so much, Mr. Green, and I think you're out of time.
Thank you.
Yes, we appreciate your submissions. Thank you very much. And I think the state of Antigua and Barbuda, there's a reply. Mr. Corbin.
May it please the Honorable Court. Your Honors, in the interest of time and the impending lunch, I have reduced our reply into bite-sized points. And with the permission of this court, I would just like to address our minds to 3 things that my learned colleagues have seemed to have lost along the way of making their points, Your Honors. And the first is that the foundation of why we are here today, Your Honors, is as a reflect of a desire amongst the community nationals to be able to bridge not just the geographical limitations, but our social, economical, and even, dare I say it, political aspirations, Your Honor. And with that, the revised Treaty of Chaguaramas, along with this honorable court, has created the CSME, Your Honor. And it is our position that if the local content policy, with specific reference to the minimization of employment, the priority treatment, or to paraphrase, Your Honors, a clear intention or a clear actions of discrimination in violation of Article 7, Your Honors, then it just means that everything that we have done as CARICOM comes short, Your Honor. Might I demonstrate to this court, Your Honor, and clarify for my learned colleagues, being my second point, that while we accepted that there is still provisions that are accessible to the CARICOM community nationals, it is our position that the LCP limits, Your Honors, the full enactment of what was intended in the revised Treaty of Chaguaramas. And in this instance, Your Honors, that falls under the preventing CARICOM nationals from equally and fairly accessing. So while we understand that Guytrin, and as my learned comrade valiantly attempted to say, has some amount of autonomy, Your Honors, it is our position that that same sovereignty that the country bears is what led them into their obligation under the revised treaty. And you cannot want to cherry pick where and when you want to comply with the RTC. It is either you comply full or you do not comply at all. And there are provisions for that, Your Honor. And in this case, we cannot accept a position. And might I further clarify, Your Honors?
Mr. Corbin, you have less than 2 minutes.
Yes, guided, Your Honor. And in the case of Ellis Richards, we would like to remind our learned comrades that the court would have distinguished that in the case of Ellis, they were dealing with a particular economic deficiency and they were assisting a Trinidadian company. And there was no profit to be gained or no economic benefit to be gained or attributed to the state of Trinidad. Hence, the objective, the proportional, and the reasonable nature that these restrictions must have, Guytrin has not met, Your Honors. And
Is that a reply to Article 30? I'm just trying to understand. What you just said, is that your response to Article 30?
Yes, Your Honor. We responded to Article 30. And in closing, Your Honor, if everything I said was not enough to persuade this honorable court of our positions, the Article 43 under the subsection 2D provides a temporary measure. So it means that the drafters of the RTC could not intend that these restrictions remain absolute. They were intended, and if what Guytrin is stating in their submissions that their hardships and the economic issues, we accept that, Your Honors. However, the restrictions were not meant to be absolute, and they were intended to be a transitionary period for the respective member state to address whatever particular issues they have. And Your Honors, if there is nothing further I can do to assist this honorable court, finally, these are our submissions.
Thank you very much, Mr. Corbin.
Much obliged, Your Honor.
Thank you for directing us to our lunch. We appreciate it very much. So, So we take a break and then we come back and make comments and
We come back to 25.
Yeah.
You could just.
Yes. so we thank you very much. Madam Registrar, you may close the proceedings.
Thank you, Madam President. Thank you, Mr. Justice Jamada. Thank you, Madam Justice Ononewu. Thank you, Council, and thank you to the staff of the Moot Registry and the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all.